Hello everyone, it's great to be here. I'm not sure why I have my phone with me, but I feel lost without it. I missed the beautiful Welcome to Country by Yvonne this morning, but I'm sure it was really powerful, as it always is. But I'd like to begin by acknowledging and celebrating the traditional owners of the land upon which we meet and pay deep respects to elders past and present, and extend that respect to Aboriginal and Torres Strait Islander people in the room or online. I'll just do a brief introduction of the panel, and then we'll get stuck straight into the research. So today we have Liz Snell from the Women's Legal Service. Liz is the Law Reform and Policy Coordinator at the Women's Legal Service. Rachael Martin. Rachael has been the Principal Solicitor of Wangmann Aboriginal Women's Legal Service for 25 years. And we have Jane Wangmann. Dr. Jane Wangmann is an Associate Professor in the Faculty of Law at the University of Technology. Her research is primarily concerned with legal responses to domestic and family violence. Jane is also currently a non-government sector expert appointed to the New South Wales Domestic Violence Death Review Team, which is responsible for reviewing domestic violence-related homicides in order to examine any gaps in the service delivery system and to make recommendations to enhance safety. And Jane will speak briefly to the report that was released late last year from the New South Wales data. So I might start with you, Jane. Jane's done a significant amount of research in this space, including her PhD and the 2020 research with Leslie Lang and Julie Stubbs. Can you please talk us through the findings of your research and the broader research landscape, and how misidentification intersects with how we understand family and domestic violence as incident-based or contextualised?
Thank you, Padma. That's on? Okay. Excuse me for having my phone, but I could talk about this for a very long time, and so I'm just going to check that I keep myself a bit more concise. So before I talk about my research, I think there are a couple of things that are really important to me when I talk about misidentification. And one is that it's not a separate issue, that I think we need to see this on a continuum, starting with whether or not victim survivors are identified as victim survivors in the first place. So we still have an issue with the police actually not acting on reports. At one end, we have misidentification as the predominant aggressor, and then we also just have simple criminalisation of victim survivors. So some of the evidence before the Senate inquiry that Moo mentioned this morning is about Aboriginal women being arrested for resisting arrest or assault of police. This is just straightforward criminalisation, and it speaks to the racism that the panel was talking about this morning. The other thing that I think is important around misidentification is it draws in a whole lot of strands of different research. So one is research about whether or not men and women are equally violent in their relationships. This is quite long-standing research. It looks at differences in the way in which men and women use violence, their motivations and their impact. Research about the ideal or perfect victim and what happens when you don't fit that image. Research on legal systems abuse. And research on the wide variety of ways in which victim survivors might respond to the violence that they experience, which includes using violence itself. So in order to put some of the research in context, I'm going to take us back a little bit because, as the earlier panel mentioned, this is a really long-standing issue, and yet we're talking, the use of a new term, misidentification, kind of suggests that it's a bit new, and yet it is quite old. So in the late 1990s and early 2000s, there was growing concern about the identification of women as offenders in the US. And this was because the US had recently introduced mandatory arrest or mandatory laws or policies. And the reason why they had been introduced was for a number of reasons, but firstly because the police were simply not acting on the reports that were made to them. But secondly, there had been some really influential research by Sherman and Burke in 1984 in Minneapolis, which said that arrest made a difference. So basically that if you were arrested, it reduced the likelihood of re-assault. Now, studies that sought to replicate that did not find such a clear finding, particularly for different groups of men. But despite that, it was rolled out across the states. Now, It did have the desired effect. It did increase the number of arrests for domestic violence, but it had an unintended consequence. And that was a significant and disproportionate number of women that were arrested. And so we saw quite a lot of research happening in the US around that time, exploring the differences, what might be done, and so on. So we start to get predominant or primary aggressor policies, and we have these here. And what they try to do is direct the police when attending an incident to look beyond the incident, to think about the history of violence between the parties, who's in fear, what's their motivation, who was injured, and so on. And those policies haven't necessarily been successful in shifting misidentification. And so that's something that we need to think about. And the reasons for this are multiple, but it's linked to the dominance of the incident framework of the criminal law, which we'll talk about a bit more. The absence of a really deep understanding about what is domestic and family violence, particularly the context of control, and this real persistence of the ideal image of a victim. And she's certainly not one who uses violence, is mouthy, fights back, uses drug and alcohol, has mental health issues and so on, all for groups that are disproportionately targeted by the police, such as Aboriginal and Torres Strait Islander women that was spoken about this morning. So Australia has had concern about women identified as DV perpetrators, and this started to emerge in the mid to late 2000s. And again, I feel like I've been rolled out because I have this history. So my research on cross-applications emerged out of my work as a solicitor at the then Domestic Violence Advocacy Service, and I interviewed women in 2002 to 2003. So we're talking 20 years ago about cross-applications. In 2011, there was a New South Wales parliamentary inquiry, and one of the things that they were tasked to do was to look at, Boxer had recently released some statistics where, again, there was a substantial increase in women being recorded as offenders. We've had the 2016 Royal Commission into Family Violence in Victoria. So there is a lot of discussion that's quite long-standing about this problem. There's certainly been less research in Australia about the problem of misidentification, but it's a growing body of research. So there's mine. There's research by Heather Douglas and Robin Fitzgerald in Queensland, who have particularly talked about protection orders being a two-prison pipeline for Indigenous women in particular. There's been the work of Heather Nancarrow on her own and also for ANROS. Ellen Reeves, significant work on misidentification in Victoria, work by Women's Legal Service in New South Wales and in Victoria, the Family Violence Reform Implementation Monitor in Victoria, in Gender Equality in Tasmania, and a number of other services. And I have actually put together a handout that lists some of these references, which I will leave at the reception desk if people are interested. And I've tried as much as possible to record their open access thing. There are a couple that aren't open access, but anyhow. So I'm briefly going to talk a bit about my research. So I've done 2 studies that in different ways look at misidentification. So the first is my cross-application study, which, as I said, is quite old. But I think it's significant, one, because its findings remain relevant, that we are still talking about the same kinds of issues. And I also think cross-applications are important because it also gets us to not only think about the police, but to think about the way in which perpetrators themselves are using the system in the form of private applications to again label women as offenders. And the second study is one that I did with Julie Stubbs and Leslie Lang, where we looked at a random sample of people who had been reported to police in 2010, so men and women, and we analysed that 2010 incident, but then we tracked them over time. So we tracked them over a 6-year period to see whether they reappeared as an offender or whether they reappeared as a victim over that period of time. And so I'm just going to talk through both of those studies. They have similarity in the sense that what I was interested in was what are the differences between men and women in terms of what's alleged about their use of violence. So I was really trying to unpack that and unpack it in different ways. So in both studies, but I'll start first with the cross-application one, I found that if you take an incident focus, men and women look much the same. So when I mean taking an incident focus, so I looked at the complaint narrative for the AVO, who used physical violence, who used verbal abuse, who used property damage. And if you just count them, devoid of context, men and women use the same kinds of violence. But if you start to look at context, if you look qualitatively, you start to see something different. And the most significant thing here, and the thing that emerges across all the studies in the US and so on, is who was saying that they were fearful. And it was much more likely that women were saying in their complaints that they were fearful, and they were doing so in a detailed way. So the occasions when men said that they were fearful, it was quite a kind of routine way to finish off the complaint. And as I said, this is a significant finding across multiple studies, and it emerges again in the other study that I did with Leslie and Julie. I also interviewed police and legal professionals for this cross-application study, and they did have a good definition of domestic violence when I asked them about it, but when I started to ask them about what they might do in their work setting, there was a real return to this incident sort of focus. And so the police would often describe, so particularly when they took dual action, so they applied for an order against both parties arising from the same incident, they felt that they could sort of divide it up. So for example, there was an incident in the house, and then a little bit later, half an hour later, there was an incident outside, but they were separate incidents. So I can take action against him here for this one, and I can take action for her for that one that happened outside, rather than thinking of them as a continuum, a sequence of events. So one example of this is, I call it the tomato steak case, just because it jogs my memory. She was trying to leave him, and she had set up and she talked about leaving, and he didn't want her to. He grabbed her phone, he took her money, all of those kinds of things. At one point in the house, he grabs a knife. She runs outside, and what she grabs is a tomato steak, and she hits him over the head with it, and she eventually actually quite seriously injures him with the tomato steak. Yet these are seen... Well, actually, this is a case where I think that the police had to take action because the injury was quite serious. But what happened at court was that she pled guilty at the very first instance. And so what we see is this question of whether lawyers are equipped to really argue that self-defence claim, and so sort of flowing into what happens at court. And I am going over time, but I'll just quickly turn to the longitudinal study which I did with Julie and Leslie. The key difference in this study was, so the offenders recorded in 2010, when we looked at men, over 93% were always or the predominant offenders over the 6-year period. And this is compared to the women where they were the primary offender in only just under 50%. So a really stark difference in terms of who was always an offender, in terms of 93% of men compared to 48% of women. Also in comparison, women were the victim or the predominant victim over time in 22% of those cases compared to only 3% of the men. So a really distinct difference. So what we saw was that men tended to be the predominant offender always, but women had a much more mixed presentation. And we need to investigate this further, because once you're marked as an offender within the system, it tends to keep coming up. And certainly when they were victimised, they were often victimised for quite a number of reports. So one woman in our sample had 22 reports to the police as a victim over the period of time that she had also been recorded as an offender. So really different experience. Again, it was fear that really emerged in these reports as a key difference between men and women. And before I hand over, I just wanted to say, I think my research really looked at differences between men and women. I'd really encourage people to have a look at the much more recent research by Ellen Reeves in Victoria, where she's looked much more at the impact, what the impact of this misidentification is, and the way it really flows and follows you, as Evie mentioned earlier, across multiple different types of systems. So the key thing from me is that I think it's really important to adopt this contextual, this deep understanding of domestic and family violence over time, moving away from incidents, and it's something that we've talked about for a long time. I don't think the coercive control offence is going to do this for us, and I'm happy to explain why later on.
We could have kept going. We could have kept listening to you.
I could have.
And we might come back to the death review after we've heard from the other panellists. Liz, the Women's Legal Service published a report in 2014 based on case files of 2010, was it? Where women were defendants. Can you talk to us about that research and what's happened in that decade? Are we seeing the same figures now?
Thanks, Padma. And I would firstly like to thank Yvonne for the very powerful welcome to country and acknowledge we're on Gadigal land and of the Eora Nation, and pay respects to elders past, present, and any Aboriginal and Torres Strait Islander colleagues here in the room and online as well. As Gail powerfully indicated, the report that we did that was published back in 2014, I'll share a little bit about the findings, and it will not be of surprise to anyone that really the similar themes that we're seeing in that report are still echoed again today, and echoes what Jane's research and echoes what Regan, Evie and Gail were talking about this morning. I note that the study, whilst informative, does have limitations, so I just want to put it out there that we acknowledge that. It was a study that was focusing on the women with whom we worked. We were representing in 7 local courts throughout 2010, and it was a small study insofar as there were 93 women with whom we worked. And also it wasn't a random study. Obviously it was the women with whom we were working in those 7 courts, and primarily our work at that time was about defending women defendants. And really that's what precipitated the study. It was, as Jane was saying, we could see in our casework that there had been a significant increase in women defending AVOs, and we were hearing a lot of this from the sector as well. And then, of course, the 2011 inquiry happened, and we were keen to actually document this a little bit further. So that's kind of what precipitated it. The study, there were over 12% of the women that we defended were First Nations, 26% were born in countries other than Australia, and just over 28% indicated they had a disability. 2/3 of the women that we defended talked about their history of violence, and often that it was multiple forms and instances of violence, and that they had they were fearful, and that fear was occurring over a period of time. For the women who were, in regards to the complaint that had been made against them, over 68% of matters, it related to a single incident. And the physical violence, where it was present in the form of punching or slapping and scratching and biting. And the biting was often in regards to on the hands or arms, which reflects self-defence. All of this, I'm sure, is echoing with your own experiences over many periods of time as well. 39%, so a minority, had a final AVO made against them, but significantly, more than 90% of those were made by consent. And I know the fabulous panel this morning talked about all the reasons why people consent to AVOs. It could be the shame, it could be that you just want it to be over, and that's the quickest and easiest way for it to end, amongst many other reasons. And I know too that that's reflected in Ellen Reeves' research in working with the legal practitioners in Victoria about there are so few opportunities. When Regan was talking about it's so hard to correct it once it's happening, there are so few opportunities for that to happen, and I'm hoping today's conversation we can talk a little bit more about, okay, well, when the mistake is made, how can we rectify it? How can we do it more quickly? 13% of final orders were in place for her protection, and despite that, she had one made against her. But interestingly, when there was when both parties were trying to seek AVOs, it was very rare that the woman was successful in getting her AVO in those circumstances. The findings, again, no surprise, many of the women reflected that on their experiences of when they spoke to police after these incidences, they felt that they weren't believed. They felt that the police did not consider their presentation credible, and that was largely in part because, as we've already heard today, the women with complex trauma and may not necessarily be able to present their narrative in a coherent manner and are quite distressed. Also, women reported that they felt that the AVOs were deliberately sought as a form of power and control, and that it would then follow them because that would always be hanging over them. I'm just going to call the police, I'm going to breach you, and that did in fact occur. And in the majority of cases, as I've already flagged, it tended to be in response to a single act of violence, and that the violence perpetrated tended to be self-defence. I also acknowledge too that there's retaliatory violence as well, and I do acknowledge that women can use violence and can perpetrate domestic violence, but predominantly it is the violence it's gendered, that it's primarily male perpetrators against women perpetrators. In terms of our practice since then, interestingly, during COVID, with the courts being closed in terms of not physically being able to get to the courts, they were open but not physically able to get to the courts, we didn't see as many misidentifications happening through the duty list because we just weren't seeing the women, even though we were available to take the calls online and what have you. But when you look at our statistics for that year, the statistics for misidentification were actually higher than previous years because we were getting those referrals from other family violence services and other places, and we were noticing the trend was that we were seeing an increase in misidentification of women during COVID. It's the same scenarios that we saw in the report. It's the same scenarios where women may be the ones who call police. They generally have a history of domestic and family violence. They talk about fear, and yet the AVO is taken out against them. There have been circumstances when police are called to incidences and they hear what both parties have to say, and despite hearing what both parties have to say, and despite seemingly on the face of the narrative of the AVO application, not seeming to have a lot of confidence in the presentation of the male, who we would say was the predominant aggressor, they still went forth in making the AVO application. And if I can give an example, in one example, police were called. The woman reported that she had closed the door, he was outside, she closed the door, and that he threw a brick into the house and broke the window and hurt his arm. He reported to police that he had been thrown out the window by her and that is how he had harmed his arm. In the narrative, the police noted, number one, that there was already an AVO for her protection, so there'd been a history of violence that she'd experienced. Number two, they noted that he was vague in how he was describing his what had happened, that he would not provide details and he would not provide a statement. And number three, they made some observations that they didn't really think his story matched what they could see when they arrived. And yet they still proceeded with an apprehended violence order against her. We similarly see stories too where women don't have access to interpreters, either at the occasion when police are called out, but that carries over to court too, that they don't have the access to the interpreters in court. And we've heard of instances where it was pretty clear that the woman who was self-representing herself against an AVO, it was pretty clear to others in the court that she didn't really understand what was going on from her answers to the magistrate. And in one instance, there was a caseworker who actually raised concerns about shouldn't there be an interpreter because it didn't appear she was understanding. And despite that, they went ahead and she got an AVO against her made by consent. In that circumstance, the misidentification was quite extraordinary, but because she didn't have legal representation, there was a lack of understanding. That's what happened. But then after that, the violence escalated. And then she didn't want to report to police because of her experiences of what had happened. But she just decided to evidence it further by taking photos and doing other things. And in the end, she was brave enough to go to another police station. And fortunately, at that police station, she had much better outcome. The police listened. The police looked behind the history of violence. The police got an interpreter so she could actually explain what was going on. They actually charged him not only for the recent incident, but also for the incidents that were the basis of the AVO that was made against her. And eventually, what was able to happen with that particular woman was she took her matter where the AVO had been made against her, and she was able to eventually get that overridden because it was obviously clear misidentification. But the point is, we acknowledge that the research that was done some time ago, unfortunately, the practices are still happening today. So really grateful for the opportunity to have the conversation, and very grateful that police are present and part of that conversation too, because it's just so important that we're all gathering to talk about these issues, because something's got to happen. It just can't continue to be happening as it currently is.
Thanks, Liz. At least one good story there.
Yes.
Rachel, can you talk about the experiences from your service for Aboriginal women particularly?
Yeah, thank you. So I also would like to acknowledge the traditional owners of the land, the Gadigal people of the Eora Nation, and I also like to pay my absolute respects to all the excellent Aboriginal women who work in the domestic violence and sexual violence sector, including the members of our panel this morning, and also acknowledge the tremendous strength of our clients, and particularly my clients who are Aboriginal women and children. In terms of the experience of, and I'm here to talk about the experience of our clients, and I must say that the experience of our clients is very similar to what the panel this morning raised. It all is very familiar. And our centre, I suppose, in terms of talking about the legal system, we always talk about being a criminal justice system, and we stop using that term because, unfortunately, it's not just for Aboriginal women. So let's talk about it as a legal system, not a justice system. The legal system doesn't treat Aboriginal women well, both in terms of misidentifying them, which I'll talk about in a minute, as well as not taking seriously their accounts of domestic violence. And often our work involves either trying to persuade police to take their accounts seriously, to take action, or we're working with women who have been misidentified, and a lot of that work that's come up increasingly for us is the work that we do with women in custody. So even though we're not a criminal law practice, we do a lot of work with women in custody, primarily looking at issues around children, victim support, their experiences of violence, sometimes making complaints against police, trying to help them reconnect with children, whether it be in the child protection system or the family law system, and also helping them to actually put on the record what actually has happened to them. I think it's, given I'm on a research panel, I think it's important that, that we hear about these experiences of the daily experiences of racism by Aboriginal women, and sometimes I think we're quick to dismiss that and say, oh, well, that's just their experience, or, they can't all be that bad. But actually, sadly, statistics do show, and hard data shows that that's absolutely true. Aboriginal in New South Wales continue to be grossly overrepresented in custody. In June 2022, Aboriginal women comprised 40% of the total female inmate population. A recent study by Boxer about the trends of the domestic violence offences related to stalking, intimidation offences in the criminal legal system also provide really good reason for concern. Boxer found that in 10 years there was an increase of 163.8% in police laying charges for those particular offences. And what Boxer found was that increase was almost exclusively attributed to changes in police's responses. In other words, the way it was being policed. Not that there was an increase in these acts of violence, but the way it was being policed. Boxer found that the change was especially profound for the Aboriginal community, with Aboriginal people accounting for a quarter of those charged with those offences. A quarter. Boxer concluded the substantial increase in stalking intimidation offences in the criminal legal system more likely to affect changes in the police response of domestic violence rather than change in criminal behaviour. So this is data showing that there is something not good, something really wrong. In terms of our clients, the experiences that Regan and Evie and Gail discussed this morning are what our clients describe. We have spoken to so many Aboriginal women who have been misidentified as perpetrators rather than victims. And for some of these women, it has meant that they have ended up in custody for offences such as breaches of AVO, for assaults that they say did not happen, or for acts of resistance to the long periods of violence that they've experienced. And yes, it's meant that they've lost care or contact with their children, either through the child protection system or through the, or children have been placed on the AVO of the perpetrator, which has precluded them from having contact with that child. They then have to fight their partner or ex-partner in the family law system or the care system to have contact with their children. Hopefully most of us know why, the many reasons why Aboriginal women don't report it to the police. But I think it's worth reflecting and reminding ourselves of that fact, of these issues. For some of these clients, the violence started when they were teenagers. And the reasons for not reporting are multiple. Fear of retribution by their family or their ex, fearful of police mistreatment of the offender. So even though they want a police response to give them safety, to give their children safety, they also want to be sure that the legal system is going to treat the offender fairly. Genuine feelings and love for the offender, or absolute fear that their children will be removed or placed with their ex-partner. We have worked with many clients who have experienced very serious physical injuries from the violence but don't get medical attention, or when they do, they lie about their cause of their injury. So that when we obtain the medical records, it doesn't say assaulted by X. There's some explanation for their injury. So when an Aboriginal woman does finally find the strength to report the domestic violence to the police, or someone else makes a call, for example, say a concerned family member or a neighbour, she is then misidentified and treated as a perpetrator. And at that point, she loses the very little trust or the small trust that she had in the police and the legal system. Their family and their friends then see this, which only compounds their mistrust, and thus the cycle continues. And as we all know, the toll on the mental health of victims of domestic violence is considerable, it's enormous. There may already be existing trauma from childhood, which is further compounded by the domestic violence, but also at the outset makes them very vulnerable to abusive partners. Their poor mental health is then used against them by the perpetrators to paint them as crazy and unhinged, and then they present as elevated and out of control when the police attend an incident. Their poor mental health then leads to self-harm by the use of, say, drugs and alcohol, which then may lead them to criminal activity and or the removal of their children. Thus, this evidence is used further to paint them as the perpetrator. I have many case studies that I could share about the experiences of women where they've been completely misidentified as a perpetrator rather than the victim. And we've found with some of the work that we've been doing with women in prison that it's not until you start talking about domestic violence and that they start to identify themselves as a victim rather than perpetrator. Because for so very long, they've seen themselves as a perpetrator because that's the way they've been painted. And they've internalised that narrative and see themselves that way as well.
Great, you've actually answered the next question about trajectories and what happens. It's not just a blip in the system. It has long-lasting effects. Jane, do you want to just briefly talk about the New South Wales Death Review, and then I might just open it up before we try and come up with some solutions.
Okay, so I'm just going to apologise to Anna Butler if she happens to be online, because I know that I will not do justice to the data that she knows so well within the Domestic Violence Death Review team. One of the key strengths of the Domestic Violence Death Review team is that we look at people's lives from birth to the homicide. And so when we've been talking about the need to look contextually, the Death Review team actually does that because it looks at everything that happened, as I said, from birth, the relationship itself and the homicide. So one of the things that the Domestic Violence Death Review team does is it talks about who's the predominant abuser and who is the predominant victim in the relationship. And what they have found, so it's now becoming quite a big data set. So before I get there, one of the reasons why the team has decided to use the term predominant rather than primary, so you see a bit of interchange within the literature, is that predominant suggests that we look over time, whereas there had been a bit of, when we were talking about the primary aggressor, there seemed to be a greater slippage back into the incident. Who's the primary person here rather than over time? Predominant gives you that sort of suggestion to look at that. So there are now, so I'm quoting from the most recent Death Review team report. Of the 206 male homicide offenders, so they're the men that killed their female partner, they were identified, almost all of them were identified as the predominant abuser over time. So 98.5% of the men who killed their female partner were the predominant abuser over time. In comparison, of the 46 women who killed their male intimate partner, the majority were identified as the predominant victim of violence from the male partner that they killed, so over 90%. And so we see a stark difference. When men kill their female intimate partner, it's because they were the abuser. And when women kill their intimate partner, it's because they were the victim in the majority of cases. There is a very small number of cases in the sample of men who have killed their male partner, but it's so small, like there were 7 cases in the sample, and so it's hard for the team to talk about that when it's such a small group. But again, most men were killed by the predominant abuser in the relationship, so 71%. In one case, the homicide offender was the predominant victim of violence, and in another case, it was too difficult to tell. So some of the cases in our sample, it is too difficult to tell who was the predominant abuser or perpetrator, often because both of them have not had any contact with the service delivery system at all, despite it ending up in lethal violence. The most recent report seeks to address the issue of misidentification a number of times because it's becoming such a topical issue. So in terms of the 245 homicides where you could tell who was the predominant abuser, there had been a current AVO in place against that person. There were a small number where the male predominant abuser had been misidentified as the victim, so 5.4%. And one of the things I want you to think about, so even though that seems like a very small percent, what you might have gathered from the earlier panel and hopefully this panel is that these cases consume an awful amount of time. So it seems like a small percentage of misidentification, but in fact there's a whole lot of work that happens across the service delivery system to try to assist that person that's misidentified and to try to rectify it. So the number itself doesn't tell us much. I guess one of my calls here is the need for greater data around misidentification. One of the problems is we don't have sufficient data on the true rate of misidentification. So Liz and Rachel have talked about their services, and if you look at the Family Violence Reform Implementation Monitor report in Victoria, again they talk about a wide range of different data sources from very high rates of misidentification to lower rates. Here we're talking about what's happening within the official system, so being identified in an AVO or a criminal charge. The numbers look small here, but misidentification happens in a range of different ways, to child protection services, to family law courts and so on. The death review team also had one case of cross-application, which had resulted in mutual withdrawal. And so all these bits of misidentification have those flow-on effects of not contacting the police, attempting to resolve it yourself, and leading to potential lack of contact with a service that might have been able to, I guess, change that trajectory to the homicide. I would encourage people to read the most recent report, because one of the things it does is try to address the concerns that were expressed about coercive control in the context of misidentification. So I'll leave you to read it.
Great. And the other work that's really interesting in this space is the work that the Institute of Criminology did last year, which looked at an intimate partner homicide and tried to look at the characteristics of the perpetrators, and really astoundingly found that 33% of men who kill have never come before any service system, not just police, but any system. And these are probably coercively controlling, well, that's the theory that they have, that they try and control their partners. When that control is challenged, they keep trying to reassert control in different ways, and when that finally doesn't work anymore, they snap and kill. And another really interesting statistic from that report is that there's just over 11% of men who are older, who've never used violence before, and that's around cognitive and physical decline. But reading the two reports together, there's also a national death review report that ANROS did with the Death Review Network. Both the AIC and ANROS reports were released around the same time. So they give a really good context in terms of what we're seeing in terms of misidentification as well. I might just open it up to questions. There's a lot that people have taken, lots of information that people have taken on.
Hi there. Yeah, just a question about the reports. Where can we find them, and could you send us the links? It sounds fascinating, and thank you, panel, for your insights there.
So I have pulled together a handout, which I meant to already put at reception, but it's in my bag at the moment. And it has the studies that Padma has referred to, some of those that I mentioned, as well as a number of others. I've tried as much as possible to give a web link for them, but for those that don't, please feel free to email me. But most of them are open access.
Thank you very much.
I do have a question online from Ellie. The Tasmanian family violence system is highly politicised, with the police having much influence over the judiciary. Do you have any thoughts on the political aspects of police misidentification? Funding is cut here when a service questions the system.
Who wants to tackle that?
I might take a slightly different approach to this question and then I'll pass over to the others. I think the ANROS research was very, and Alan Reeves' research as well, was very interesting insofar as it highlighted that police seem to be cautious in how they approach these things. And so perhaps erring on the side of caution, put forward applications which seem very obvious to us to be misidentification, but they seem to think it's okay because it's going to go before the courts and there's going to be some judicial oversight, and the judicial officers will pick it up. And there's that, what Ellen Reeves talks about, the safety net. But similarly, the magistrates are relying on the police to be getting it right in the first place, and courts have very long court lists, and so there is this co-reliance, I guess, on each other, that they're each doing their job properly, and so therefore the oversight may not be as great as what we would like it to be. Now, I understand it's different in Tasmania insofar as they have police-issued AVOs and don't necessarily have the same judicial oversight, so I'm not able to speak to the Tasmanian context as much, but I think that issue that ANROS research highlights and the recommendations it made about how to address it would be great to have some conversation about that. And some of those recommendations, and I feel like Padma can speak much better to this than I, but some of those recommendations in terms of better guidance for police, better policies for police in how you identify, particularly the coercive control issues, and looking at it in a context rather than incident-based approach, and having supervisory oversight for that. And in the case of the judicial officers, that they better understand how they can strike out applications when they can see it's clear misidentification, or dismiss, or revoke, or some other mechanism. So I would just throw that out. I know it doesn't quite answer the question, but I just think in the New South Wales context, these are some of the issues that we're interested in.
So I might repeat a bit. I think, so it came through my study too, is that police had some confidence it would be sorted out. It would get sorted out in the system. But you're going into this system that's quite under-resourced. You've got duty lawyers, and as a legal academic, I teach your upcoming lawyers, and I recall saying this here at an earlier forum last year, that lawyers don't get any training on domestic and family violence in their compulsory undergraduate degree. And so how are they really equipped to come out and argue self-defence or argue that it should be struck out when they're not necessarily given that skills and education? And of course that flows through to who's in our judiciary. Are they sufficiently educated to identify misidentification? Because I think there are some cases where women have used force that the police shouldn't exercise discretion around, because they were of such a nature that it's not really a police level to do that kind of thing. But when it comes to court, how do these other legal professionals deal with it? I also think, and this might be asking something too much of the system, is that we should be able to even have a conviction for an assault and still say it's not domestic violence. That domestic violence means something else. It's not just who did what to whom, it's about the full context. And that we, even if an order is made or so on, we should be able to say, oh yeah, she did that and it was wrong and it got the attention of the law, but it's not domestic violence. And to be able to talk about victim survivors' use of force in a more sophisticated way.
Could I just add one other thing to that too, and that is what came out of Eleanor Reeves' research with legal practitioners in Victoria, that the only opportunity that legal practitioners were getting to raise and challenge the misidentification was if they took the matter to a contested hearing. Yeah. And that obviously has risks and kind of contributes to the many reasons why women may consent to an apprehended violence order made against them. So it would be great if there could also be some discussion about how can you fix the issue much quicker and not let it go all the way to a contested hearing.
Sorry, can I just add to that? One of the things in my cross-application study was also the legal professionals didn't think a consent order was of consequence. You get your order, he gets his order, who cares? But it was of consequence for a whole lot of reasons. And so that's that education thing. And the cross-application, at least in my study, the most common result for those was mutual withdrawal. No one got an order in almost half of them. And followed by mutual orders. One person getting the order was in less than 20%, and that was the woman, and that was only really if it was contested. And so you're just not getting that kind of discussion.
I'm not sure I'm answering the question either, but to add to what Liz and Jane were saying, I think, yes, resourcing is absolutely an issue for the profession in terms of the systems, the systems that are there to support people going through the court process, as well as resourcing for the police, and that's the whole discussion in itself. But this is one of the reasons why a lot of us advocate for specialisation. And I know there's not a lot of support by government around that, but if you had specialist courts with the right people there to understand domestic violence, to have the time to actually really unpack what's going on, then you would get better results.
Yeah, and I'd just add, ANRO's released the National Community Attitudes Survey earlier this year, and if you think about the attitudes of the community more broadly, we've got a situation where we're going backwards, where 41% of Australians think that men and women perpetrate domestic violence equally, and that's gone backwards. It was 23% in 2009, and even less than that back in 1995. So something's happened, and I think some of the discussions around coercive control, because they haven't been sophisticated, because they haven't taken into account the fact that coercive control is almost a framework rather than within which domestic violence can be seen, it's slipping into men and women both use violence. And recognising different forms of violence as well is also leading to that. So while we don't know causally what's happening, it could also be that the backlash is working. But it's interesting to think about it in terms of our attitudes as well. Any other questions?
We have a couple of comments online that I think's been quite addressed. Police are often making decisions based on what evidence they have to present to court in that moment rather than investigating further. If police do not have evidence to support their view to the court, police will cover all bases and put out AVOs that way. Perpetrators will often not admit to violence and the victim will. This gives the police the evidence they need to put an AVO out on the victim because she admitted to it. I've taken women to police with 2 books full of incidents. Police are only interested in the incidents where he physically abused her rather than threats to harm verbally or intimidation. They will note only physical incidents, and that takes away the context. This needs to move away from single incidents of physical assaults.
Does anyone want to comment on that?
Hi there, thank you so much. This is a really great discussion. I'm Kira, I'm from PIAC, and I was just going to comment about I'm a former criminal lawyer, and those comments about really making nuanced submissions in court is really difficult around saying anything negative about the victim or the context of the relationship, and that's really challenging. I was wondering whether you think that something like inserting something into the bench books or having, some significant changes for magistrates might do anything to help them understand, or how do you think we can, make people understand about the contextual?
I will hand over to Liz, but I think we do have an issue. We've set it up in this really dichotomous way. You're a victim or an offender, and that's clearly not, it's not as clear as that if we want to use those labels. It's a lot of, we need to talk about the way in which women with all their agency might respond to their experience of violence, and they do it in a multitude of ways. But this deeper understanding the criminal law is this really dichotomous thing, guilty or not guilty and all those kinds of things. Sorry, now I've lost track of... Oh, you reminded me of an old article, and I haven't referenced it, but it's by Lee Goodmark, who has recently written a book called Imperfect Victims. But the old one could well be 20 years ago, is when is a battered woman not a battered woman? When she fights back. And she starts with this account of her client going in and admitting that she did it. And all the other lawyers are in the room going, really? You're going to run that argument? Because it's not going to be successful. But there must be a way in which you can admit and explain. And again, we are asking a lot of the legal system, but we have been talking about this for 20 odd years. We have to be able to push it somewhere else.
A great question, Kira. I'm always going to say, yes, we could always do more work in our bench books. But I think there's a lot of things that can happen. I think that is absolutely one thing that can happen. I'd actually like to see a lot of preventative work happening too. I'd like to see more work at the front end. I know we've touched on very briefly the family violence reform implementation monitor down in Victoria. 21 put out a report accurately identifying the predominant aggressor. There are, I think, 16 concrete recommendations of what you can do to change the system. And the report is great because it doesn't acknowledge it's not just a police problem. There's a lot of conversation today about police because they are the first responders and obviously a key part of this conversation, but it's not just the police. It's the whole of system response, it's a police response, it's the legal and courts response, it's child protection's response, as we've heard, and it's a whole range of other aspects too, and also looking at the intersections of how it impacts on differently on people, including, as we've heard this morning, First Nations people. Part of the prevention that I really liked, one of their recommendations about was the monitor recommended that before police enter a women respondent into their police computer systems, they have to consult with a specialist DV service to see have they correctly identified the predominant aggressor. If we could trial, and I acknowledge here in New South Wales, there are pilot sites happening at the moment that I think started last August. I think they're in 5 pilot sites where WDV, Women's Domestic Violence Court Advocacy Services, are co-located in police stations, and the government just recently announced funding that would continue for a further 12 months and expand to another, I think, 5 or 6 locations. That is kind of a similar recommendation to what's happening in Victoria, but it would be great to hear more about how is that going to work in practice, and how can we explore that preventative role further. When it comes to, okay, the police have misidentified, how do we rectify that? That's a huge space that I feel like we're not even really having conversations about it. The Family Violence Reforms Implementation Monitor, again, makes recommendations about that. How can courts get better at rectifying that? And I know NRO's research has picked up on this, and Ellen Reeves' research has picked up on this as well. But it would be great to also explore rectifying. When, in our experience of when we're seeking to try and advocate with police to say you've got it wrong and here are all the reasons why, when we go for representations, it's a lengthy process. And while that process happens, there's generally an interim intervention order against the woman while they're trying to sort it out. During COVID, there were instances of where that interim order was in place for 2 years. Eventually the matter was withdrawn, but that was 2 years of unnecessary stress and trauma to that woman. So I just think there's so many opportunities for a preventative approach, so many opportunities of what you can do when it happens, and absolutely I think bench books is part of the massive potential for solutions.
Hi, I just wanted to add on to what you were saying. So I manage a WDV CAS. My experience, and this is only my experience, but my experience further on from that is that we work really closely with our solicitors in our area, probably because we're those pains in the arse that are always there. Well, I'll own that because I am. We work really closely with legal aid as well as, and most solicitors in the area know who I am, so we can have those robust conversations. But what I would say is a really key thing that we do, because we do have female defendants that we support with legal rep, is that we will always support the solicitor, whether it's our duty solicitor, her private legal rep or her legal aid rep. We will always say, we've had her as a client before where she's been a victim, and we'll write a support letter that will get given to that magistrate. So my experience at our courts is that our magistrates are very open to those conversations and those submissions by our solicitors, and we will always take that angle if that's what she discloses when she has her engagement with our solicitor. So it's not the solution, but my thing is, way back in the day when we used to have law students come to court and you could pick them a mile away. They'd all come all fresh-faced and ready to solve the problems of the world. And then they'd be at Campbelltown Court and there'd be a fight outside. And we go, yeah, welcome to Campbelltown. But what I say to them is the way that I view a good solicitor over an average solicitor is the way that solicitor engages with the services in their area. So you can be the best lawyer in the world, but if you don't know the support services for your client so that they do get their mental health support or their drug and alcohol or DV or whatever it is, you're not doing as good a service as you can for that victim or your defendant. So I just wanted to say, I think the key thing that I always focus on is the collaborative practice that we have with the entire system, because if we can be that voice and stand alongside all of the people that have to support her, particularly in court where it's sometimes really crappy, then we're doing a better job. And I think that that's something that we can all do every day. It's not something that's hard, that needs to be evolved or have guidelines or whatever. It's just something we can do.
The only thing that I would add is, I mean, we talk a lot about systemic racism within the police, but equally it applies to the legal profession, to the bench, to society in general. So I think when we're talking about system changes, we're talking about changing the whole system, and it's about raising those issues with everybody, because it's not just, we all have conscious and unconscious bias. That's part of being a human being, and I know I'm stating the obvious here, but we constantly need to check in with that and talk about that and reflect upon that. And I think lawyers and the bench all think they're above that, because by virtue of whatever degree they have next to their name, and that's just not true. So I think that's the other part of the conversation. It's not just about understanding the complexity of domestic violence and the context of why women may resist, may do certain things, or the complexity of why they might be misidentified, but it's also about understanding our own bias and our own prejudice.
It's a great point. I did a session with specialist magistrates in Victoria on the NCAS. I've been talking about the NCAS a lot. And one of them challenged me using methodology as the basis. Like, he clearly didn't like what I was saying, clearly didn't like the, especially the attitudes around sexual assault. And so just challenged me to say that methodology could not have produced the results. I was so tempted to ask him whether he was a statistician, but he clearly wasn't. But being a lawyer means you know everything, and you can therefore say that, experts in the field who've used a really, really robust methodology can be questioned. So there is that internal bias when you don't want to hear what you don't want to hear. Question.
Hi, my name is Paula. I am a former police officer through the 90s and the noughties, and I now work at eSafety training the police. I'm on online crimes and all that sort of stuff. Thank you very much for today. I really get a good insight. The 2 points that I wanted to get some insight though was, when I was working, most lawyers would advise their clients not to say anything, leaving the police in a position where they had no option but to put them through the court system. And there was no early referral to get the matter sorted before it went. Like, they had to wait 3 weeks for a mention date, and as you said, there was no interventions. So what is this where it's going? Why is that still not happening? I mean, this was a conversation I was having 25 years ago, and I've been a passionate advocate for like AVOs and protection orders for a very long time. So
I'm happy to kick this one off. Excellent question. I don't have the answer. I mean, I know we've been talking about resourcing issues, and we do hear resourcing issues are an issue in terms of police, the legal sector and the court sector contributing to delays and contributing in part to that issue. Why can't we do more prevention, early support process? Why can't we? I totally agree with you. Why can't we? In fact, that's where we really should be investing a lot more of our time and energy. I think also having conversations where police are part of the conversation is so crucial, because they're such a key player. So I think that's very valuable. I think it's useful to reflect on how can the different players in the system be better supported? So how can police be better supported? How can the judiciary be better supported? How can the legal profession be better supported, in addition, obviously, to supporting the victim survivor? And some of that, I think, is in terms of, obviously, training being a key part of that. And we would always say that in regards to domestic and family violence and abuse and coercive control, we think it's fundamentally important that training is co-developed and co-delivered with people with lived experience, with cultural safety experts, with people with disability and LGBTQ communities as well. We would also, and I think there's also value in not just co-developing it that way, but also in having multidisciplinary training. So you're bringing everyone together. You're bringing police together, judicial officers together, legal practitioners, the DV sector together. So you're having those multidisciplinary conversations and training. So I think that's also very valuable, and we should do more of that. I'd also love, and I feel like I'm stealing Jane's so passionate about what I'm about to say and has said so many fantastic things, but we always say training is the answer to everything. I know Jane has said this many a time. And when you look back, as Jane has said, on different inquiries, we always say just need more training. But if that was the answer, this problem should have been solved well long ago. So obviously we need to bring a much more critical eye to the training that is occurring at the moment. What's working, what's not? How does it change people's practice? How does it help to better identify domestic and family violence and coercive control and reflected in changing your practice of how you do things too? And then publish the results, because that's the other thing about, we understand that there might be independent evaluations of training, including police training, but we never see it published. So there's a lack of transparency around that. And so we feel like there's a lack of accountability, even though that may not necessarily be the case. That's what it's looking like because we can't see how it actually works. And in terms of accountability, and I know this was a conversation of the first panel theme too, we would warmly welcome there being greater accountability, including, I know we keep focusing on police because they're such a key first responder result. There's got to be greater accountability about police responses to sexual, domestic and family violence. It was great we had the Auditor General's report last year. Obviously we're waiting for the 12-month report of that to be tabled in Parliament to hear what's happening to progress that. Women's Legal Service New South Wales, and I know Ringa Bayer and many others have also, DV New South Wales, long been advocating for regular independent auditing of the police response to sexual, domestic and family abuse. The positive aspect of that is it helps to build public confidence, because then police are acknowledging what's working well, but also when things don't work well, and we know, and I'm very mindful that although I did share a story about good policing, most of the time when women come and see us, they're only ever telling us when it goes wrong. We don't get contacted for when it goes right. So we do acknowledge that there may be there is good policing, but we only ever hear it when it's going wrong. And so that's the story that we bring, and it's the important story that we give voice to, because that's the experience of the clients with whom we work. But it's really important to be... I've just lost my train of thought, sorry. But, the accountability. It's really important in terms of building public confidence that if you're open about when things are failing, and you clearly outline what you're intending to do to address that, that helps to build public confidence. And that's what we would like to see a lot more of. I know Gail referred to the Commission of Inquiry in Queensland and the recommendations around that. We would love to see more transparency and accountability, and having an ongoing mechanism to follow that up. We see that as the independent, some mechanism for independent monitoring and evaluation. Sorry, that was so long-winded.
Thank you.
I suppose the only thing that you would add, which is really, I suppose, what Jane answered the question before, it's an adversarial system. And as long as we're within that system, that's why your advice is going to be, and I'm not a criminal lawyer, but you learn this in first year law school doing criminal law, tell your client not to admit to anything, because the system forces that. That's what you do the best within the system that you have. And I don't, unless you completely change the system, then I think that will continue.
And there's reasons to do that. And I think your point, certainly as a lawyer, we never got any training on domestic and family violence. So we go on those principles of criminal law rather than understanding the context. I think there was a question.
We do just have a question online. Do you know some reasons for the hesitance of governments to incorporate data and influence from the community sector?
The hesitance of governments to do...
To incorporate data and influence from the community sector.
Is the question asking why is the community sector data not valued? Yeah. Excellent question. Because it's like this is a no-brainer. As everyone who's been talking today, and as I know you know only too well in your own experience, this is not a new issue. It's been going on for years. There is evidence after evidence after evidence, a report of not just reports that are written, but people's experiences that are incredibly valuable. I don't have an answer, except that I share the frustration in the question that's been answered, because it's like, enough is enough. How many more bloody reports do we need to say with the bleeding obvious that we've got to do something? And that involves everyone coming together to have the conversation, and it involves governments committing to that. There's another whole lot of things we could say in terms of what we actually need in reforming our Crimes, Domestic and Personal Violence Act in New South Wales. It needs to start with a review of the Crimes, Domestic and Personal Violence Act, picking up on many of the issues that Jane's already raised in terms of our system is failing because currently it recognises all forms of violence, as long as it occurs in a domestic relationship, which is very broadly defined, equals domestic violence. That is not right. That's got to change.
Hi everyone, my name's Amanda Morgan. I'm a Yorta woman and survivor. I'm just graduated law school and I've been awarded a Churchill Fellowship this year to look at trauma-informed approaches to legal processes for historically underserved survivors. And so I'm wondering, there's been some ideas floated about having independent lawyers for key witnesses in domestic violence matters. And I know that Mark Dreyfus recently has announced a massive overhaul and commission and inquiry roundtable. I'm just wondering if you think that independent lawyers are a trauma-informed initiative and whether that would be appropriate, or is there another initiative that maybe we need to look at instead, like a specialist counsellor who has a background in law who can advocate?
I might have a crack at that. Mark Dreyfus's reforms yesterday were around sexual violence. I think we're at the point around sexual violence where we've had reports for 25 years that have tried to make changes to the legal system, and we haven't seen a change in conviction rates. Victoria is a really good example of where we started reform back in the early 2000s. We've tinkered with the criminal justice system over and over and over again. And whether it's having independent lawyers, whether it's having extra support, whether it's having specialisation, we haven't seen a shift. And one of the things I'd say to that is, again, if you look at community attitudes, 4 in 10 Australians don't believe a woman's account of sexual assault. And we have a jury system that relies on unanimous or majority verdicts. So you can see why we're not getting convictions as well, apart from all the attrition that happens. I actually think we need a completely different system. I think the adversarial system, in terms of sexual violence especially, is just failing women. Only 13%. If we think about the fact that 1 in 5 women have experienced sexual violence since the age of 15, 87% of them don't report it. And of those who report, we've got such low conviction rates, it's clearly not working. So maybe we do need to look at, and when you talk to victim survivors, often, especially if the perpetrator's known to them, they're not looking for a prison term. What they're looking for is either for an acknowledgement that it happened, an apology, a range of other things that the criminal justice system can't necessarily give you. But I was talking about criminal law the criminal justice system rather than independent lawyers in other proceedings. Do you have any ideas about that? And congratulations, Amanda.
Thanks, Padma.
So I won't talk about the independent lawyers, but I wanted to say congratulations as well on both your degree and your Churchill. One of the things, well, there's 2 things I want to say. One is I am worried that the trauma-informed recommendation is becoming a bit like the training and education recommendation, repeated rhetorically all the time, without us really deeply getting into what do we mean by trauma-informed and what do we mean by trauma-informed in a domestic and family violence context, which may be something else as well. So I think we need to be careful of keeping government to account about the fact that these recommendations, you have to do more than simply repeat the phrase, tell us what it means. And then just picking up Padma's point about the system, one of the things I always repeat, so it feels like I repeat things a lot, the 2015 Family Violence Death Review report from New Zealand is an incredibly powerful report. And one of the things they point out is we talk about a family violence system, or we talk about a criminal legal system, and it's not a system. It's just something that we've patched together. We call it a system, so it kind of tries to make sense, but all we do is band-aid over it. The system itself remains the same. We just ameliorate it a little bit here and there, and we need to do something more about that. But I think Liz might be able to say something on independent lawyers, I don't know.
Congratulations too, that's awesome. I think there can be a role for independent lawyers. I'm very mindful, as numerous people have said, that the criminal legal system really does not work for complainants, be it sexual violence or domestic and family violence, noting that there's also a crossover of those two. And the role that an independent lawyer could play could be in terms of, look, there's a provision in the Evidence Act, section 41, about improper questions you may well be aware of. There's been research done that suggests that that provision is not used as often perhaps as it should be in challenging what improper questions have been asked. I actually think there's a problem with the wording of the section because it starts from the presumption that you're going to ask improper questions. Like what? You shouldn't even be asking them in the first place. But you've got to wait until they're asked before you can say, no, that shouldn't be happening. Could an independent lawyer perhaps be objecting more in those cases? That could possibly be one of a whole range of other things that they could do. But I also take the point that you make about the multidisciplinary approach and the value in having a multidisciplinary approach as well.
Yeah, Jan from Moving Forward again. About 15 years ago, I was working in a refuge and we had a woman come in and she was named as the defendant because she had bitten her partner on the stomach. And I don't think she was a habitual stomach biter. So I'm sort of wondering, why would a police not understand that she was in a headlock and the only way she could get out of it, because she couldn't breathe, was to bite him on the stomach? Where's the common sense? Do you know what I mean? You don't go around biting people on the stomach. So there's a reason. Not recently, no. So there's a reason, and I just don't know where common sense comes into all of this. But also, since that time, it was not long after Johnny Howard had done his trick with the family law, it changes, and I have noticed a trend from that time on that AVOs are used in family law and men are using it more often and women are being named as defendants. And in particular, just recently in COVID, we have had a huge increase in women whose English is not their first language have come to us, and we are now still working with women for years. The most recent one's 3.5 years she just had her criminal matter heard. But we weren't allowed to say anything about these charges, 21 charges against her, because a family law matter was happening and she needed to get her son back. So, you know, what can we do when we're told, don't talk up about, you know, a state matter because the federal matter's happening, and then we've got to appeal this ridiculous treatment that she's had. But then who do we go to? Who's going to listen and who's going to overturn if the charges are, you know, are kept? So do you see a correlation between family law and the way AVOs are being used and defendants are being named?
Definitely. There's ANRO's research that shows that there's the family law system is used, well, we call it systems abuse, but it's definitely. And we're also seeing, I talked to a bunch of family law judges recently, and we're now seeing coercive control being weaponised as well. So women who keep their children to stop the violence from the man has been termed as coercive control. So the family law system, very much so, is. And the interesting thing, again, if you look back to attitudes, people think that women make up stories of violence. Over a third of Australians think women make up stories of violence in custody disputes.
But there's also the fact that there's been so much coverage on women being killed or women being victims that there's this backlash of not all men. Yeah. Women do it too. You know, we're seeing that all over any of your, your phone stuff. It keeps coming up. People, even the way the media reports it. So it's almost like we're supporting this trend of men being able to prove that women are as bad, if not worse. I don't know. That's just what it looks like. Yeah.
It's everywhere.
Yeah, but women are supporting it as well. Some women.
But that's the point of patriarchy, I suppose. I mean, you know what I mean? Like it's just, yeah. I mean, there's probably much better feminists who can explain it than me. But it's the structure. It's a whole system, and we're all, we're part of it as well, And yeah, women are victims of patriarchy, both in terms of we consume it as well, and we espouse a narrative as well, because that's how powerful the system is.
But when people have so much power over the lives of women and children, why are they not properly trained? Why not? And why aren't we demanding that they are?
That's a rhetorical question.
We have 2 minutes left, so I'm going to do one more question, if that's okay.
Yeah.
All right. Thank you. I think just following on from what everyone is saying and Jan was saying, picking up on the issue with cowed women, and I think, knowledge is power, and we can see that here. And the legal system, whether it is a system or is not, it is totally against, going continuously against the tide. With all the great things that we've got in place and, everything else. We've heard this morning of the racism that exists within our Indigenous sisters accessing. Cowed women have exactly the same double layers. Women of faith, Muslim women have triple layers they have to go through. But I see, how can we reduce harm in the now? Because changing the future is hard, but it has to begin from today. So I think we like to I'd like to propose that we think about how do we utilise what we already have in place in reducing harm and bring each other collectively into the space where we really have the hard conversation. Because I'm no lawyer, I do not understand the legal system, but I do understand people and I understand the heartache that women have to go through and how much healing we have to do while the system, the legal system, is going through that process of, especially when women have to juggle between the family law and the criminal law. I mean, I've had to learn myself of all these things so that I can heart explain to some of our team members, to explain to their clients with confidence that this is the system, but we can work through it. So there is a reducing harm effect, there's the healing process, and the shifting while we're here collectively that can be doable, while we are continuously making a difference, so that that the majority of people out there can shift the way they think that women are just as bad as men in affecting harm on men. So yeah, that's really all I'm saying, is that things can be done. We can do it as of today, hopefully, together.
Maha, what a wonderful way to finish. Feeling positive and optimistic that we can actually change things if we work collaboratively together. Thanks everyone for a great session. Thank you, panellists. I think that was incredibly rich. Can you join me in thanking the panellists today?